Welcome to the in-house training for junior associates at our law firm. I hope that prior to viewing this video, you have already completed two important tasks. Firstly, I hope that you have looked through the infographic that we provided in our training environment. That infographic had materials about the main ethical code that all of us as international practitioners must obey. And within that particular infographic, there were a number of plus signs that had additional information that you were also expected to read through. I, in particular, want to point out that we want you to be familiar with this very last plus sign where an article has been shared with you regarding how law firms set up an ethical infrastructure within the law firm. Please make sure that you have read through this and understood how to deal with any type of conflict of interest. Back in our training environment, I've also asked that in advance of continuing this video, that you make sure that you have read through this ethics training for junior associates fact pattern. If you have not, please pause the video, read through it, and then come back to continue the training. Here in our ethics training for junior associates, we're focusing on this fact pattern about a 47-year-old assigning partner. This particular assigning partner has been friends or at least has attended law school with Adkal. Adkal is of interest for us because Adkal has actually asked that the law firm advise him. He is a software developer for a company called Gotpal, and this company has a global presence. It would be advantageous if the law firm were able to advise Adkal, because then they would also expect to get future business from this very large and important company. The issue, of course, for ethical matters is whether or not this particular relationship that Boklin and Adkal had in the past as colleagues in law school some 20 years earlier would in some way provide an ethical problem for the law firm. Now, of course, I would like for you to, when you think about this question, refer to the principles within the IBA code to explain and inform why you think that this will or will not be a problem. And again, remember, there's always ways to argue in both directions in these types of cases, but I would like you to at least come up with an outcome to this or explain why certain facts are important to know before you can give such an outcome. Think about it, write down your ideas, and then come back to this video and see how I suggest we think through this problem. I think that if you take what you have found out about the code, you will know that there may be an issue regarding independence because this would be a friend, and therefore one would be concerned whether or not there would be a problem regarding independence. Now, there are many factors that can weigh in here because firstly, we have an issue that they have been not in contact for some 20 years. So the question of whether there can be independence may have been mitigated already by the amount of time that has passed. However, it is very important to explain why it is that you think that there are no ethical issues and to give good justification for it. So again, we would always raise the fact that there's a friendship and that could bring into play independence of the law firm and of the individual that's advising. Again, thinking about our ethical rules, we could also mention that indeed it will depend on what type of advice that is being sought, because perhaps this advice can't be even delivered by ADCAL, but by someone else within the law firm. And in that case, someone else in the law firm, if we put the right things in place, would be able to deliver advice quite independently to this client. And so again, we have to think about the subject matter and whether or not it's actually going to be the person who knows this other client that delivers the advice, because if it's someone else, then this issue may also have been resolved. These are matters that you would have to discuss and think about in your team meeting as you're deciding whether you can ethically advise a client. And one of your pieces of advice may simply be, this law firm can take this case, but we suggest that it not be done by the person that he knows, but by another department or by another partner. So again, returning to our fact pattern, there was a second question. And here we gave ourselves a little bit more information. And we said, let's say that the law firm Watkitt has decided to advise Buckland. Then after an interview, we find out a little bit more about Buckland's background. He's been with the company for 10 months, and he's been working on this tracking app for the COVID virus. And Buckland has leaked information about this, some potential privacy issues with the app, and he's leaked that to a member of the press. It turns out that this press, Teleprompt, is actually already a client of the law firm. And so though currently they are not representing them in any current matters, they have had and have been on retainer for Teleprompt to advise on any controversial issues regarding defamation or also libel. And therefore, there arises yet another ethical issue. Please think about the question that's in red here. What ethical issues must Watkitt resolve before advising Buckland? And again, think about the IBA principles. What are those ethical issues? Pause this video, write that down, and give yourself some time to think and decide what the outcome should be here and what can be put in place to ethically advise in this situation. Hopefully you've thought about this part of the IBA code, the conflict of interest. Again, conflicts of interest generally arise in two situations. Either a situation where the client that is seeking advice is coming and that client is involved in a matter in which you are already representing or advising other clients that are in the same subject matter. So there could be some type of conflict between two clients. But it could also arise when there is a conflict with someone who's a member of the firm. So perhaps there are business interests involved in which a member of the firm might have some type of business interest in this potential client, and that could also mean that there would be a conflict of interest. Whenever you see these types of situations, it's important to recognize that it doesn't always mean that you cannot advise. It simply means that you might have to go through extra steps in order to be able to advise ethically. So looking at the explanatory note and reading through the information in conflicts of interest, you may have been able to come up with a way to handle this issue. So certainly you have the possibility at all times to represent someone at the same time that you're representing another client in a similar matter. However, you must always disclose to the clients any type of conflict of interest. So disclosure becomes extremely important. in these matters. And it's always advisable to do the disclosure in writing. So that is something that that lawyers will always do in order to be in an ethical advising situation. Additionally, even if you disclose, you still cannot do anything without consent. And again, that consent should be obtained in writing after you fully explained what the consequences are for the different clients. So disclosure and consent must occur. And most of the time, you also have to show the way in which you're making sure that the one part of the law firm that's representing one of the clients is not in communication with the other part of the law firm that's representing the other clients. And you have to do that by putting some type of an information barrier up. And when you put up an information barrier within your law firm, it blocks the files about the clients so that they're not available to the team that's representing another client. But you also have to tell the individuals involved that they may not communicate with each other regarding the cases. And so these types of information blocks are quite are used quite often in many jurisdictions. And so these are the various protocol that you put into place to ensure that the conflict of interest is properly dealt with. So to summarize, it is still possible in this particular fact pattern to continue and to advise both of these clients, but some things have to be put into place. Firstly, it has to be disclosed to the clients. You must receive the consent from the clients, and that consent must be informed based on very, very broad explanations and very detailed explanations to the clients about the consequences. And then likely you will put a barrier, an information barrier in place. Those are sometimes referred to as firewalls. When you put those in place, then the people in the law firm that are working on the separate cases cannot communicate with each other, and they cannot access the files of the other client. Again, we have finished now our training session. Please again review the ethics codes that we have provided for you. And as a follow-up to this training with your collaborative group, we also recommend that you do some further independent learning. And this can be done within your collaboration team. You can ask the researcher in your collaboration team to find out more information about the use of firewalls and information blocks in law firms. You can do this by searching the internet. In addition, discuss with your collaborative team how you would want to disclose conflicts of interest to a client. You can describe the steps and the procedure that should be taken. Also consult internet resources to help you understand how to do that. All of this information you can keep inside of your MS team environment, and you can use it during your team meeting. Thank you for attending this seminar.